Welcome everyone. Tonight we're going to be talking about at least 12 estate planning mistakes and how to avoid them. All right, we're going to talk tonight about a number of estate planning issues, and boy, that sounds like an exciting topic. One of the interesting things about moving to Hartsville is you find out things, you get to know people, but you have no idea what they did in the past life. Most people know me from here, from being president of the library, or from being on the planning board. But during my career, I was an estate planning attorney. And over the course of that career, I was in private practice. I spent some time as probate commissioner, as judge, as bank trust officer, and then for the last 30 years or so, I just kind of specialized in sophisticated charitable estate planning. In other words, if somebody wanted to put a name on a building on a college, I helped them with the financing and setting up trusts. And what that gave me an opportunity to do was to travel all around the country, putting on continuing legal education seminars for lawyers, and then also meeting with individuals. And so I think I met with something over 2,500 families. So I've seen quite a few problems. But the good news is that as a part of that, I've also raised just shy of $500 million in charitable gifts. So that's the good stuff.
For the library?
No, not that's the first question I get. Well, I don't see any of it for the library. So we're gonna go through some things, and we're going to talk about some issues that I ran into on a number of occasions, and we're going to talk about it in English. If I start going into the legalese and all that kind of stuff, stop me. The idea is that it's got to be something that you understand and that you relate to. So, number one, let's start off with everyone has a will and the evils of probate. So, I'm not sure if you're aware of this, but every one of you, whether you've written a will or not, you have a will. If you haven't written one yourself, the state of Maine has generously written one for you. Which is nice, except they probably don't know you very well. For example, according to Maine law, if I die, my estate does not automatically pass to my wife, Ellen. She gets 50%. The other 50% goes to my kids. Now, for most people, that's probably not what they have in mind. And considering the look on my wife's face, I know that's not what she had in mind. But that's the idea, is that they wanted to put together a default so that if you have nothing else planned, we do know where the property should go. That also becomes important if you are devious. And I've had devious people show up. I had a gentleman show up in my office, and he said, you may notice that I'm not here with my wife. And I said, yeah. And he said, we aren't getting along. I said, I'm not a divorce lawyer. And he says, well, I'm not looking for a divorce, but I just don't want her to take all the money that I've spent my whole life earning and spending it on her next husband. So what I want to do is to put together a will that gives a very minimal amount to my wife. Well, that's not a particularly nice thing to do, but one of the things that the will, that the intestacy, the will that the Maine draws up for you does, is it says, this is kind of the minimum also that you have to give to a spouse. So if I decide that I want to give 25% of my estate to Ellen, she can go into the probate court and do something called taking against the will and say, I have a choice. I can either take what Dan left me in the will, or I can go with the default that the state of Maine said, and she gets 50%. So even though we think of intestacy as something that's kind of a default and really is kind of a fail-safe, what it really does is it protects families from people who are trying to do something a little strange. Which brings us to the probate court. There have been articles for as long as I've been practicing And I'm retired now. I should mention that I'm retired. I have no licensure in Maine, so I'm not going to be drawing up any documents or anything like that. One of the things is people are concerned about the evils of probate because they see this as being a very complex system. All probate is designed to do is to systematically take property that is in one person's name and transfer it into the names of the people who should be receiving it ultimately. And that means that we have to collect the assets and make sure that expenses are paid and funeral debts and estate taxes, if there are estate taxes, and all that kind of stuff, and take care of everything so that when the probate process is done, then we know that everybody got what they should have. It takes a while, but it's an efficient way of making sure that things get done. The question is, do you need that protection? Probate court is great protection if you know you're going to have a family fight. And there have been a few family fights. So rather than trying to settle things and do things on your own, you use the benefit of the probate court to see to it that things are doing well. So, evils of probate, not if it's used appropriately. But we'll talk later about ways that if you want to, you can avoid probate entirely.
And it's not expensive to file either, right?
No, it isn't. Let's see, it helps if you have it the right way.
It does?
And it even helps if you do that. And sometimes that isn't even work. Number 2, joint ownership and the know-it-all relative. Everybody has a relative who knows it all. In my family, it was my Uncle Art. Uncle Art was always that close to making it big. Sometimes it was that close, and sometimes it was that close. But in spite of the fact that when he died at 84, he never did make it big or small, the one thing that he had was an opinion on absolutely everything, including areas that he knew nothing about. And that goes to estate planning. Now, even if you don't have an uncle like that, you watch YouTube videos, which are almost as bad as the know-it-all uncle, because the kind of advice you get on there is, can be a bit iffy. But here's what my Uncle Art said. If you want to do it cheap, and that was his big thing, you never want to pay retail for anything, which I understand, I don't like retail either, but if you want to get by cheap, what you do is you put everything in joint names with somebody else. Not a bad idea, because if property is in joint names and you die, what does the probate court have to do? The probate court's job is to take something that's in your name and put it in somebody else's name. If you have property in joint names, nothing for the probate court to do because the property goes directly from you to whoever the joint owner is. Husband and wife, domestic partners, joint ownership, great idea, because these are the people that you're going to want to have anyway. And they're the people who you want to have own things with you anyway. But here's the mistake. People decide that for their convenience, they're going to name one of their children as a co-owner of their accounts. Why is that a problem? You've just made a gift. And once a person is a joint owner, if I put my son, and I'm glad he left now, if I put my son on as a joint owner of an account with me, he can now go into the bank at any time and empty it out and use it for whatever he wants to. That's not an efficient, that's not what I have in mind. And there are ways of doing that better, and we'll talk about powers of attorney later. But the idea that you want to take things and put things in joint names with your kids, or here's even a better one, I'm going to put it in joint names with all my kids. Now you've got the opportunity for 3 or 4 different kids to completely empty out the account, and guess what? These people are married to people over whom you have no control. And so at that point now we get into the greedy in-laws who have decided that, well, since you really have been taking care of mom and dad, you really ought to pull some of this money out, because I'm sure that if we got a boat, they'd really like to go under the boat with us. Those are the perils of joint ownership, and that's why keep the joint ownership to just the person who you are going to be dealing with immediately, and who you want to have as an owner, and who you wouldn't care if they completely emptied out the account.
Dan,
Yeah,
question. Good friend of ours, her husband died maybe 15 years ago. When he died, his credit card account with all kinds of miles and so forth suddenly disappeared. She was not able to access that. In terms of joint ownership, is there something one should do to avoid having to lose everything, assuming your spouse dies before you?
okay, the question, for those who didn't hear it, had to do with what about something like an airline miles account where all of a sudden you lose it if you die? The only alternative to that really is to have a power of attorney. A lot of the reasons why you can't transfer it has nothing to do with the nature of joint ownership or individual ownership, but it's the contract that you have with the airline in terms of how you accumulate and redeem miles. Okay, let's get on to the next one. Shortly after my wife and I were married, this is called do-it-yourself wills, or you can do your own plumbing. Shortly after my wife and I were married, we bought this old fixer-upper house. And it was built in the 30s, and the plumbing was apparently done by a guy who worked at the steel mills and who did all the plumbing based on whatever he could steal from day to day, because every 3 feet there was an elbow and all that. And so Ellen said to me, we need to redo the bathroom. And I said, great, let's hire somebody. And she said, no, we can do this. And so what we did was, she bought me, you know, this is before, again, the internet, she bought me a Time Life book called You Can Be Your Own Plumber. There's a picture from it, and look at that, it's wonderful. There are all sorts of pictures, and it tells you what kind of tools you need to do. And so I got all of that, and I did the replumbing of the shower, and I turned off the water and all that, because I knew, because I said to do that, and I turned on the water again. And when I turned on the water, it came out, and it missed the bathtub, and it came down the floor, and went into the hall, and into the kitchen. So the next thing that she did was she called our friend the plumber, Wendell, to come over and to take a look at it. And over the course of about 3 days, Wendell took care of everything. And it was absolutely wonderful. The job was well done. You could turn on the faucet without seeing streams of water flying everywhere. And what he said to her, to Ellen, I will never forget. He said, if Dan ever wants to do this again, please let him. I can use the money. Now there's a small moral to this story when it comes to estate planning, which is leave this kind of stuff to the professionals. Because one of the things that happens if you try to do a do-it-yourself thing, there are little things that can mess you up. Because a lot of people, when they take a look at one of these pre-printed forms, they say, I don't need that paragraph. And the moment they take care of that paragraph, they realize that that relates to 3 other things in the document. This is a job that should be done by a professional. Doesn't have to cost a small fortune, but there are enough issues that arise in doing estate planning that you really need to have a professional do it. I was named as this is the ugly knick-knack rule. I was named as the executor of an estate of a gentleman, longtime family friend. He and his wife had 4 kids. His wife passed away. His 4 kids could agree on absolutely nothing, except that they trusted me to be an executor. That was a mistake that was corrected later on when they eventually decided that none of them appreciated the job that I did. But here's what happened. When you decide that you're gonna be dividing up your stuff, you're never really sure what your family wants and what they don't want. When my mother died, and my father died before, when she died, she had a collection of Cupids. She loved Cupids. I hate Cupids. So I said, you know what you really have to do is just make a list of all of them, because, you know, when people say, well, what are we gonna give Jen for her birthday? Let's give her a Cupid. So she, you're scared to live in daylights out of you, turn the light on in the room and Cupids are going, so I said, make a list of all the people who have given you Cupids, and we will see to it that when you pass away, they can have them back, because I figure that's only fair, give them back to them. Which she did. And Ellen was really happy. She was our Cupid maven. And she went through the list to try to give things back to people. We did a really good job of giving things back to people, including the people who said, no, that's okay, you can keep them. The problem is this, as she was getting older and not feeling well, she had decided to give some of the Cupids back to the people before she died, but she never made a note of it. So if you're gonna make a note of things to give to people, make sure that if you actually give it to them, that you strike it off on the list so people know about it. Cupid, I don't consider those to be the ugly knickknacks. This is the ugly knickknack. The family of 4 kids, they got into their father's house, and the first thing they want to do is divide up the personal effects. Some things are, cash is easy. You can get $10,000, divide it by 4, and everybody gets $2,500. The interesting thing is that you're never really sure what people think are going to be important. And we walked into the kitchen, and there was a plate that was held together by egg whites. Yeah, that was my grandma's favorite thing. If it breaks, you put it together with egg whites. In a plate rack on the wall, all 4 kids said, I really want this because I was the one who broke it. Now, my question to you is, when that thing got broken, which one of the kids admitted to doing that? The answer is none of them. But it ended up being something that was so important to the family that they all decided that they wanted it. And my solution was kind of a solid one. Well, let's break it into 4 pieces and you can each have it. That didn't go over well either. So here's the deal. You never know what it is that your family member really thinks is important unless you give them an opportunity to talk to you about it. For our 50th anniversary last summer, we had all the kids around, had our 3 kids and all of our grandkids, and said, you know, what's important to you? If you could have just 1 or 2 things from that we've owned, what would you like? And we got some really interesting ideas, and we were able to then make a list of that, which we will put with our will. You don't have to put it in your will. It's called a separate memorandum of personal property, separate from the will, but kept with the will, that says, these are the things that I want to go to different people. It works extremely well, and it eliminates the problem that almost everybody has. And I say, well, how did it go when your mother died? It went really well. You know, there was just that one thing that she always promised that I would have, and my sister got it, and you know, it doesn't bother me, but you know, she really didn't deserve it. And all of this anger just starts welling up. It's something that you can avoid greatly by making a memorandum of personal property. If there's one important thing, that's the one.
One thing that we did when my mom died, there was 3 of us, and there was 1, 2, 3. So the first person, you just picked a number. First person was 1, second person was 3. 3 got 2, then 3 went, and they got another pick.
Yep.
Yeah.
So I don't know if you ever, it's a easy mathematics.
There are a number of different ways of doing that. But what that assumes is that there isn't that one or two items that people really want, and that you don't have somebody saying, I'm gonna take this because I know my sister wanted it. Wickedness comes out at that point.
What we agreed to was that if two of us wanted it, we would simply cut cards.
Oh, either, I thought you were gonna say, we'll go back on the back porch. All right, so that's the ugly neck rule. Make sure that you, regardless of what kind of a will you have, keep a separate list of things that you want special people to have.
Does it need a specific signature or some kind of notarization or anything like that?
And just sign it and date it.
Okay.
It doesn't have to be witnessed, it doesn't have to be notarized, but just make sure, you know, particularly what I like to see is that you just kind of keep a series of them so you can see what's going on. It's better to do it that way because when my grandmother, I just forgot about this. My grandmother had this idea that she was going to put a sticker on the back of things that had different kids' names on it. Which is great unless you've got one cousin who's a sticker picker and decides to move stickers from one thing to another. You think you can't make this stuff up, but, but they're all gone, so they won't see this video anyway. Okay,
We're the first person in the house.
so yeah, do a memorandum of personal property. Age limit.
Where's Phil?
Back here.
Okay. All right, number 5, disinheritance. Okay, who wants an estate challenge? A couple of things about disinheritance. Disinheritance is never fun, but there are times in which you decide that there are people who should get little or nothing from your estate. They can be family members, they can be kids, they can be grandkids, they can be relatives, whatever. You have an opportunity to disinherit somebody in your will, but there are a couple of things that people do all the time which are absolutely wrong. Number 1, never say to anybody who challenges anything in this will, I give $1. What does it do when you tell somebody that they're entitled to $1? It gives them what we call standing, or a right to go into court and say, that's at $1, it really shouldn't have been $1. It gives them an opportunity to argue. Second thing is to list in excruciating detail why that person shouldn't get anything. One of my favorite cases, this doesn't happen to be one of mine, thank goodness, but it was a case where somebody, a gentleman, had one child, his wife had died, and he was so totally, absolutely disappointed with his child that he said, this is my last will and testament, I declare that so-and-so gets nothing from my estate, spent 2 pages outlining every way in which that kid had disappointed him during his lifetime, and then concluded, again, I want him to get nothing from my estate, signed it, witnessed it, notarized it, but he never listed anybody else in the will. He died intestate. Who got everything? Son. If you want to disinherit somebody, the best way to do it that gives no wiggle room, don't say why, you just say, for reasons best known to me, I direct that so-and-so gets nothing from my will. Because there's no way that they can attack that, as long as you were competent at the time you were doing it. So that's the way to handle disinheritance. Don't talk about giving them $1 or list a bunch of other stuff. That works. That tends to work the best. All right, we're up to IRA beneficiaries because the IRS is patient. You have an IRA, not a Roth IRA. I'm not talking about the one where you've already paid the taxes. An IRA or a 401k that's rolled into an IRA, you haven't paid taxes on it, it's accumulating in value, and at a certain point, once you reach 70 and a half, then you have to start taking money out every year as a required minimum distribution. Because Uncle Sam is only so patient. right? Now, so in the event that you are unable to withdraw all of your money from your IRA during your lifetime, what do? You'll name a beneficiary. It's fine to name people as beneficiaries. It's fine to name charities as beneficiaries. It is awful to say, make the beneficiary my estate. Because then it comes in through the estate and it gets taxed at the highest rate people ever get taxed in their entire career, which is it's called income in respect of a decedent. You hit the high, you have to hit a pretty high number to get the highest marginal rate if you're a regular taxpayer, right? You want to hit the highest marginal rate in income in respect to a decedent, it's under $15,000. So now you're paying highest possible tax rate on that. So name individuals, name as a backup other individuals, name charities. In fact, if you're interested in doing charitable giving, my favorite way of doing charitable giving is to do it by way of an IRA. Because the government gets nothing. Any transfer, it's just like right now, you get, you give, if you're over 70 and a half and you decide to take your minimum, required minimum distribution, and instead of taking it yourself, you tell the IRA administrator, pay this over to charity, there's no tax on it. It used to be really nice because you make a gift and then you'd be able to take a charitable deduction off your tax return. How many people can do that anymore? Very few. However, if you do that directly from the required minimum distribution, it never shows as income for that year's taxes, which keeps you in a lower marginal tax rate, and charities get it. Perfect way of making a charitable gift. Yeah.
Assuming I predeceased my spouse, we have money in an IRA.
Right.
I'm getting required minimum distributions now. At that point, her expected lifetime is significantly longer than what mine was, which is what the RMD is based on.
Right.
Does that change for her?
Yes, it does, because you no longer have a two life.
But it's in my name at this point, so it's not a two life.
But it's no longer in your name,
No.
because you have,
Yeah,
so now.
somewhere down around.
Yeah, that's.
Changes, isn't it?
I was the executor of the estate of my uncle, and people say people never take it when they go. He took it, because we were never able to find it. We just aren't sure which way he took it. We have a pretty good idea. No, if you die, what happens is that and you name Suri as the primary beneficiary,
Yes.
it rolls over and becomes it'll become separate from her own, it'll be a rollover IRA, but it's based on a single life.
But, and if it were going to our kids, they would have a 5-year period over which they would have to withdraw it. Does she have the same 5-year
No,
limit?
no, spouse is different than children for that. Yeah, and we can talk at another time about, the best way to handle those kinds of IRA distributions to minimize tax and all that. My big point is that the one thing that you don't want to do ever is make your IRA payable to the estate. Name people, name charities, because payable to the estate, big problem. Let's talk now about naming your executor.
Yes, she is.
No, promise me you're not gonna take personal affront at this, because I'm gonna just talk directly to you. Okay, first of all, people have this idea, they have two ideas about naming the executor, the person who's gonna handle their estate when they die. Number one is I have to name my oldest child. Why? Because they have, well, yeah. There's no,
Primogenitor.
yeah, primogenitor, yeah. Okay. Second reason is that somehow naming somebody as an executor is a reward. I am honoring you by making you the executor, and I see people shaking their heads right now. If you've ever been the executor of an estate, you understand what headaches truly are. Because you've got all sorts of people who are coming at you with different ideas. If you want to reward somebody, don't give them a job, give them money. So if you think your firstborn child is wonderful and so you were going to reward them for making him an executor, name somebody else as an executor and give them cash.
Somebody other than the family, is that what you're saying?
You can name an executor. I'm a big fan. If you don't have somebody who is particularly noteworthy in your family who would like to do that, is name a corporate fiduciary as the executor of your estate.
Corporate fiduciary.
And the reason for that,
What do you mean by that?
a bank.
Okay.
Yeah. And the reason you do that is because they do this for a living. They understand this stuff. When I was working as a trust officer, that was my job, is I was personal representative of people's estates. And if I have time at the end, I will tell you the story, one of my favorite stories about that required a professional. So don't reward people by naming them as executor. Think in terms of, is this a person who has at least some organizational ability and that you can trust? If you have that, then you're fine. So I think you're okay.
Yeah,
I think,
hopefully.
yeah, okay.
Sure.
Okay.
Moving on.
We'll see. And should you ask that person if they want it?
Yeah, it's always a good
Yes.
idea to do that. You know, my idea when we were younger and we had kids and we had to name guardians,
Yeah.
tough question. Who do you name as guardians? And I have a whole nother talk about doing that. But here's a great idea. Tell about 10 or 15 couples that you've named them as guardians for your kids. Because then you have all these people who are praying for your continued good health.
When, excuse me,
Yeah.
when you name or ask a bank to be your executor, is there a requirement of payment to the bank? Or is that something that,
Not
like if
until.
you have an account there, they have to take you on?
No, it's always a good idea to find out whether they have the capability of doing that
Okay.
work. But there are no fees or anything
How
until they.
how do you determine if they have the capability?
You talk to other people.
Yes, oh,
Yeah, one of the things to do is you can just look at the county records, the will records, and that will show who the executors are of all these estates, and a number of banks will pop up immediately to the top. And so that makes it easier.
Until what? You said twice. There's no fee until,
Until you die and they have to start doing the work.
whereas you have to pay them.
Yeah.
Yes.
Yeah, you're gonna end up paying them probably 1 to 2% of the entire value of the estate, which is well worth it.
as opposed to your daughter, which is 0.
But you know what, but if
Who's
you're
gonna let
asking,
you at that
but if you're
point?
asking a family member to do that, you know, you request that the executor serve without bond. But there's nothing to say that you can say, I want you to act as executor, and here's what I expect you to charge to perform that function for me. That's perfectly legitimate. Did you have a question?
No.
Oh, okay. All right. Next question, has your will expired? Technically, wills never expire. In practicality, a lot of them do. Now, one of the things I didn't say at the very beginning here, which is that of all of these rules of 12 mistakes and how to avoid them, I have violated probably 5 of them. Okay? I need to update my will right now, and the reason is we moved from California to Maine.
Yeah, different rules.
Different rules. California is a community property state. They treat ownership of property very differently. They have a very onerous, terrible probate system. Here, big deal. But you know, you move here. So when do you review your will? Did you move to a different state? Have you had a change in family size? people died, more kids added, grandchildren,
Spouses?
spouses, yeah. Did you win the
You're having
lottery?
spouses?
Yeah, so, did you win the lottery? All of these things, just think in terms of major, was there a divorce in the family? Maybe you had something where you wanted your daughter and son-in-law to be taking care of things in your estate, but they just had a really messy divorce. Which kind of goes back, let me just digress a minute, back before. Remember what I was talking about with the joint ownership thing? Once you put things in joint ownership with your kids, your child, who you now own things in joint ownership with, files for divorce. What assets are included in that divorce? Everything that their name is on. So now your joint property with them is included in the divorce proceedings or in bankruptcy proceedings or things like that. Yeah, ugly. Okay, so take a look and see, have you had major life events? Because those are the things that don't make your will invalid anymore, but it may mean that it's not doing quite what you wanted it to do. So the general rule of thumb, which I have no reason to question, is that you ought to take a look at your will every 5 years. Who remembers 5 years? Nobody. Make it 4 years. Do it every leap year. So just like, twice a year when we change the clocks, you change your battery, on leap year day, haul out your will and see if it still meets your needs. If you find out that there are issues with your will, because you've named somebody that you really don't want to name as executor anymore, or that you have designated to receive a gift in your will that you really don't want anymore, or they died, yeah. What you do, you don't have to start from scratch. So this wonderful, if you paid for this wonderful, big, thick document, it shouldn't be that big. But we get paid by the page. You don't have to start from scratch. It's very often easy to just make a change, an amendment. It's something called a codicil, in which you say, this is a codicil or an amendment to my last will and testament dated so-and-so. I wish to make the following change. I wish to change the name of my executor from so-and-so to so-and-so. I reaffirm everything else in my prior last will and testament. Minor change. Just make sure it's witnessed, notarized, and you're all set. Okay? Okay, I could not help but put this in. It isn't as important as everything else, but sometimes people just want to be really clever when they come in and decide to do their estate plan, and they try to do things that are a little bit nefarious. At our first house in Indiana, we had a neighbor whose name was Jen. Jen was... Nothing escaped Jen. Do you realize people were sitting out on your front porch drinking wine last night? Oh, yeah. Yeah, we do. That was sort of us, Jen did that. She was extraordinarily cheap. Her husband had died. She had no children. She had 2 surviving sisters and a brother, and decided it's a good time for me to redo my will. So she came in to see me. I said, okay, Jen, what do you want to do? And she said, I want to divide my estate among my brothers and sisters in equal shares. I said, okay, 1/3 to him. No, equal shares. Yeah, that's 1/3 to here and no, equal shares. I said, so what part of the math here is confusing you? And she said, no, I want them to be equal. What I want them to do is when I die, I want them to come in with their financial statements. And so by the time they get my money, they will be equal. Yeah. And she was serious.
Wow.
Oh my God.
Yeah. I told her that the better way to do that would be to make individual gifts to the people who were more in need during their lifetime. And that it was probably not an appropriate thing to leave as her lasting legacy. But that's the kind of thing, people try to do crazy stuff, so it's something you really ought to avoid. All right.
Ouch, I love this picture.
Some things simply do not belong in your will. I love that. You know, one of these things is not like the other. Never put your final funeral instructions in the will. Because it may take, you know, with everything that goes around when somebody passes away, the last thing people are planning to do is to quick find a will. You should be leaving your funeral instructions and separate instructions. What kind of a wake do you want? Do you want a service? Do you want to be cremated? Do you want to be buried? We had a period of time for a period of months when we were first married, when a lot of individual members of our immediate family died. You know, it was like 6 of them within a period of 3 years. It was horrible. And we were sitting at, I don't even remember which funeral it was at, but my cousin happened to be a mortician. And we're sitting next to him with Bob, and we said, you know, Bob, I think we've eaten about all of the floured ham buns and Jell-O salad that we can handle. What I would like to do is to get your commitment that when I die, that we will not have ham buns and Jell-O salad at the reception. He said, well, what do you want? And I said, well, I was kind of thinking more in terms of pizza and beer. And Bob said, I don't think we can do that, Dan. So why not? He says, I've met your friends, and I'm not sure we can get our hands on that much pizza and beer in that short period of time. Those kinds of instructions should not be with the will. They should be with your executor, who also, by the way, should have a copy of your will. They should be with the funeral home if you're working with them. One of the most interesting ones, and I don't think I've ever told this story. I had a woman come in and said, and she was very smartly dressed. Oh, she was just absolutely, completely put together. And she said, I have a special instruction for my funeral. I said, okay. As long as it's not illegal, we can do it. She said, I want to be buried in a really good bra. Because I want the girls to look good. So it's true. It's absolutely true, and she did look good. But you know, if you
Were you the,
no, I was not. I had nothing to do with it. But, you know, if you do have special instructions, if you want somebody to sing or to play or to do something else, those are special instructions that in the heat of the moment, you really don't want to have to deal with. So keep those things outside of the will. Powers of attorney. Okay, what's the alternative to putting things in joint names? You need a power of attorney. There are 2 kinds of powers of attorney. Powers of attorney over money, which is a financial power of attorney, and power of attorney of health care, to make decisions concerning your health. Powers of attorney generally, a general power of attorney, and by the way, if you're looking for something free, this is where you get it, because Maine has statutory powers of attorney for health care and finance. You just go onto the website, you can download it, fill in the blanks, and it's free. So there is something free here. Power of attorney, you sometimes see it during your lifetime, even when you're all healthy and everything, when you're trying to buy a house and somebody who's supposed to sign it is out of town, they give the right to somebody else to sign on their behalf. That's called a limited power of attorney. You have the right to do it only for a specific purpose or for a specific time period. What we're talking about is what happens if I'm not able, for any reason, to make an intelligent financial decision. That is called
Based
a,
upon who's,
no, you aren't supposed to say that it's too late for me to do that. This is called a springing power of attorney because it springs into action at such time as you need it. So instead of, remember we were talking about don't put your kids' names on your accounts? You give them a power of attorney that gives them the right to act as your representative at such time as you are no longer able or no longer wish to do that yourself. And you can turn a springing power of attorney into an immediate one and say, here's the power of attorney, this person has full opportunity to act on my behalf. It's an extraordinarily valuable thing, and it allows people to do things like get into your safe deposit box. If you have things in joint names and you don't have kids' names, getting into a safe deposit box can be a lot of fun. Power of attorney allows you to do that. Second thing is the healthcare power of attorney, which talks about your general goals, and you can make them as specific as possible about taking care of yourself physically when you're no longer able to do that. If you have an accident, who consents to surgery? If you're having, if you are under anesthesia for something or other and something needs to be signed, that allows for that. If you're dealing with end-of-life issues, you can decide to what extent do you want doctors to be heroic. And there's a wide range of opinions on there, and there's also a wide range of options. You can decide that I want the doctors, and I've dealt with people who have said, you know, I put this almost as, I don't know any other way to put it. They are so afraid of dying that they want to be kept alive by whatever means possible for as long as possible. That's your option. If you wish to take that approach, you can. But you can also say, listen, if I'm going to die no matter what, just keep me comfortable. Provide food and water, yes or no. Certainly provide drugs to keep me comfortable. But those are important things, and that is something that the person who you are giving that decision to is not necessarily the person who you are giving your financial power of attorney to. And I can get really cynical here and say that you don't want the same person to make your healthcare decisions, to make your financial decisions, but it is something to think about because you're dealing with two different mindsets. You've got family members who are really good with money but haven't had an empathetic bone in their body, and you've got people who are just loving and all that, and they have nothing because they just give away all the time. So you don't have to have the same person doing it, but you can. Healthcare powers of attorney, final directives. If you have a will, you should have two copies. You keep the original, and you have a copy that you give on unexecuted, like a photocopy that you give to the executor. Two of them. You don't want them floating around all over the place. Two is plenty. Or with your attorney. You can also leave it with your attorney. Healthcare powers of attorney, you can never have too many of those things floating around because you don't know when you're going to need it. So you keep one, you give one to the person who has the power, and then whatever doctor you have or hospital you have, you put it in a chart. Years ago, that was a much bigger issue because hospitals and doctors didn't talk to each other electronically as much. Now, if you've got the record someplace, it's good someplace else. Yeah,
Does that equal a health proxy?
yes, health
Because
proxy.
most doctors will ask, do you have a health proxy? And they'll give you the form and it's like 10
That's right.
pages.
and my chart has it.
Yeah,
Right.
yeah, so the fact that it's there eliminates issues. Now, once you've done, it's not important to tell everybody that I have given my power of attorney to my son. Well, first of all, you give your power of attorney first to, if you're married, to a spouse or a domestic partner or whatever. And then you name a successor. You can name a successor power of attorney holder too. to say if Ellen can't act, then Phil does, or whatever, okay? And I just forgot where I was going with that.
You don't have to tell everybody.
You don't have to tell everybody. The one thing you do need to tell everybody about is what your health care options and preferences are. Because in many, many cases, you will find, and I've had this situation where I sit around the table with 4 people and 3 of them are all in agreement on what's to be done, and the 4th one is in complete denial. And different people for their own lives have decided that they want to continue their life with medical assistance longer than others do. Your family should know what your desires are. Yeah, you.
Problem I had with my dad, there was no question, it was a DNR, no extra, whatever, let him go. However, having a heart attack at his home, the ambulance picks him up and takes him to the emergency room, and they are going to use every method to keep him alive.
Yeah,
I mean, they have to.
yeah.
So the two are in, yeah,
It doesn't
competing with each
solve,
other.
yeah, what Hugh was asking, for those who didn't hear, is, there are cases where the ambulance arrives and tries to keep people alive regardless of whether there's a DNR on. We're not gonna solve every issue, but we can resolve 80 or 90%.
Even in the emergency room.
Even in
there's
the
still-
emergency room, yeah. So, yeah,
Is there any kind of override, if you have, let's just say you give your kids the power of attorney, and so they have those rights, but say you have a disagreement, about what you wanna do, like they want you to move to California or something, and you say, no, I really don't wanna do that. Can you say, sorry kiddo, but I'm not doing that, or do they have the right to say, well, I'm power of attorney, so that's what you're doing?
it depends on how you've characterized. The question is, what happens if the power of attorney holder wants to do something you don't wanna do? 2 protections on that. One of it is it a springing power? So if you're capable, if you're competent yourself, that power, you may say that power of attorney isn't effective right now. However, you can also, powers of attorney aren't all or nothing. You can put in your power of attorney that I give my power of attorney holder the right to do blah, 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 and blah. However, that power does not extend to moving me out of the state of Maine or putting me into an assisted living facility or whatever. You can put all sorts of limitations on there if you want them. All right, we're at number 12. Pros and cons of living trust. Remember we said right at the very beginning that the role of the probate court is to take property that's in your name and in a systematic way put it in somebody else's name. What happens if when you die, you don't have anything in your name? Then there's nothing for the probate court to do. That's what a living trust is all about. You take the property that you own right now, bank accounts, house, investments, and put them in a trust where you name yourself as the trustee. So basically, you are your own money manager. And so I'm the money manager of this trust. And I've named my wife as the backup trustee, or perhaps we're co-trustees. So when I die, is there anything in my name? No, because it's all owned by the trust. And so when I die, the trust terms say, everything that was being used to take care of me now takes care of Ellen, and then if something happens to her, it gets distributed to children and charities. Okay? What that does is it avoids completely the probate process because you haven't owned anything during your lifetime, because you've been nothing but a property manager for it. Well, there are exceptions to that. There are minor things like You know, cars and boats, sometimes those aren't put in there and personal effects, but that's minimal. What that does is it's a very systematic way of seeing to it that you can transfer property in a very private, individualized way without getting the courts involved. What it does not do is it does not avoid paying taxes, it does not avoid funeral expenses, it doesn't avoid any other debts that were owed. You still have to pay those, but what it does, it allows you to do that quietly and without outside influence. It's wonderful. The cons to doing that, not a whole lot of them, unless the people that you have named as trustees aren't reliable. And the trustees of the living trust tend to be individuals. So if you have questions about whether you can trust the person that you've named as a backup trustee, well then maybe you can use the probate court for what it was designed to do initially, which is to protect you and what you've done.
How about if the trustees, you trust them, but each thinks very differently than the other?
Okay, disagreement among trustees, happens a lot. What you do is you have a winner. You say tie goes to, if you have two trustees, you say if there can be an agreement, this is the person whose decision is final, or that the two of them pick a third person to make the decision. So that's how you kind of get around that. Okay,
Okay.
yeah.
The living trust extremely expensive
No.
compared to a will?
About probably 3 to 4 times as expensive, I would think. But the expense up front saves a lot of expense later on, generally. There are very few downsides to a living trust. Okay, that was the 12 points. I've got 2 bonus ones. And I've got 2 minutes to do it. Okay, bonus number 1. Greedy in-laws and speeding through the process. We've been talking about setting up your estate to this point. What we also need to talk about is what happens during the process of the estate. Because you've got people who are saying, you gotta take care of everything right away, it's time to move on, why are you holding on to this? You gotta clean everything out of the closet, you gotta do this, you gotta do that. These people don't have your best interest in mind. Your best interest is to use the speed that you are comfortable with. And if you are going to be making some gifts to friends, do it when it's on your timetable rather than theirs. When my father died, at the funeral, my cousin went up to Ellen and said, "Can my husband have your father's suits?" At the funeral.
You can't make this up, trust me.
Yeah. See, I could have had 12 mistakes without even leaving my immediate family. But that's the issue. People will try to rush you and tell you what you ought to be doing, and it's not their decision, it's your decision. So do what makes you feel comfortable. And if it takes you a while, if you just don't want to move anything in a room for a while, that's fine. You have the opportunity to grieve and to make transitions however fits you the most. This is no one size fits all, and let no one make you feel guilty for it. Last thing, it's called the will game. And it's a problem that we've had in our house. The will game is this: you sit in the living room with whoever your executor is, could be a spouse, one of your kids, and you go and you take turns finding the will. That's usually a fun game for one person, but the other person, if both people can't find the will, you've got an issue. So it's something to think in terms of And I found out that this was a problem when Ellen was sitting at a seminar and I was having all sorts of fun with this. And she was strangely quiet in the car and I said,
Ellen?
yeah, Ellen was strangely quiet. And I said to her, you know, didn't you enjoy it? She said, I have no idea where the will is. So make sure that your family members know. Okay. Do you have any, that's as far as I've got. Yeah, do you have any questions? Yeah,
I was gonna say that, you're talking about putting stuff into a trust,
yes.
the key point is you gotta make sure you do that. So say you have your bank account, or say you just happen to have a bank account with 6 different banks, and you don't put any of them in the trust, then you have this trust, but it doesn't mean anything because none of the banks are in the trust.
That tends to be one of the biggest problems, is they have this beautiful trust document, but they don't fund the trust. Which is why when you create a living trust, you also create a companion document called a pour-over will, which says that when I die, anything that is in my name which was not in the trust gets immediately distributed over to the trust. And so that becomes just a matter of paperwork for the court, and you don't have to get involved in the whole probate process for that. Yeah.
I have one daughter, I have one house, an old car. She's in my will as, she gets everything, including my old dog. She's still alive. What would be the benefit of me putting that, which is very little, in a living trust? If there's no difference in taxes that she's going to have to pay.
It is mostly convenience after you were to die. How
Okay.
quickly she could get everything transferred to her.
Okay,
Only children situations are perhaps the easiest one.
okay.
I know, I was an only child.
Yeah, she ain't
So
gonna
I had
fight
no
with any
fa-
other kids.
I had internal struggles, but you know,
Yes,
nothing with,
yes.
nothing with anybody else.
And a second question, and I don't know if this is the place to ask it, but I was told that there's some kind of difference about putting property in my daughter's name, like 7 or 5 years before I need to go and say assisted living.
Okay. You're
Is that
talking-
something else for another time?
You've really hit a tricky one. The question, for those who didn't hear it, was putting property in a child's name 5 or 7 years before you go into assisted living. What you're talking about is ways to create what we call artificial poverty in order to qualify for Medicaid benefits.
Okay,
There are a lot of ethical issues about that,
Okay.
which I won't get into. The practical issues is that enough people were doing that the rules concerning Medicaid eligibility give them something called a look-back opportunity to
Right.
look back and to see what kind of questionable transfers may have been. So even though you try to do that, you may end up, it may not work for you at all.
okay.
But
So there's no benefit to transferring over property to her now? I mean, I'm healthy, I'm collecting Medicare, but I don't have any intention of, you
yeah,
know, in the next 5 or 7 years to be needing to go
that's,
into assisted living, but,
that's purely a case-by-case
okay,
basis.
Okay.
Whatever you feel more comfortable with.
Is
Yeah.
there a danger for transferring it over to someone else while you are still living, active and so forth?
Is there a danger of transferring over? Yeah. You know, you obviously get along well with your daughter.
yeah, she's a peach.
Yeah, okay. They have a tendency to hang around people that you don't have any control over.
True.
And that's the biggest problem. You know, she ends up in a relationship that goes bad, somebody else comes in and cleans out her money. It just gives an opportunity.
Okay,
There's a whole another thing about senior scams that we can go
yeah,
into it another time as well.
Okay.
But
thank you.
yeah, you bet. Yes, sir.
You mentioned disinheritance. If your will, does it, I just question, why do you have to mention the disinheritance in the will? I mean, why not just have the will, 50% of the proceeds go to this son, 50% go to this daughter, and just be silent on, say, the third child?
The question is why put in disinheritance language? It's a legal concept called the pretermitted heir, which says that
How's it called again?
pretermitted heir. And the idea is that that person says, there must have been a mistake here. I was inadvertently omitted. And it gives them an opportunity to come in and to question whether you were thinking clearly at the time, whether you thought, boy, you know, I thought I had 3 kids, but I guess I only have 2. You know, so that's the reason why you do it. Is it blocks off the opportunity
Clarity.
to come in for something else. All right. Well, thank you very much.
Thank you.